about one area where government gives about 1.5 points for sportsmen and women who qualify to join public admissions in public universities. That is also not a scholarship. So I want us first to be very clear there, that government already has a policy for the well-doing children who qualify from senior 6 to join this public university. They look at, number one, their performance. That's when government is able to give a 1.5 points for you to qualify. But for the purpose of scholarships, I want to emphasize this, friends. I welcome the innovation. I also want to say, I request for your support, because we all mean well for the people of Uganda and for the sportsmen and women of Uganda. If money is permitted, is available, why not?
Thank you.
I thank you so much.
Thank you. Members and ones will get their fees out of the donations within Parliament. It is out of the donations. We do not have an education fund account, but it is out of the donations from the Commission, where most of you have been. Next, Minister, let me first hear from the Minister. These are leaders. These are Sembabule District. They are led by Mr. Katumba Mosa, who is also...
I want to thank you, Right Honorable Speaker, for allowing the people. So I want to welcome you this on that. And two, Right Honorable Speaker, I want to thank you that we were given a seed school. We did not have a seed school in our constituency, but we have one. The only request that we have is the school stopped at senior 4. We want more 1 billion for to have senior 5 to senior 6, Right Honorable Speaker.
Can we hear
so
from
I
Mayor
want to
also?
welcome you to the 11th Parliament. Thank you.
Thank you for in. I'm their woman member of Parliament. God bless you.
Have you had
I want to thank the Honorable Member of Parliament for Maogora County, Honorable Namuga, who are coming from, and are represented by the women of the government. I'm also the representative as the minister. I thank you.
Thank you. Where is Ogwang?
Honorable colleagues, remedies available to the party, to the petitioner. These include 3.1, restitution. This is defined in the Black's Law Dictionary, 19th edition, as the return or restoration of some specific thing to its rightful owners or status. From the legal perspective, the parties are put in a position they would have been if they had never entered into the illegal agreement. The petitioner stated that they had paid to the government a sum of $6,690,000 United States in performance of the obligations stated in the impugned agreement. During the committee interaction with the Honorable Minister Evelyn Anite and Honorable Kasai, the issue of the quantum paid to the government was not disputed. The petitioner averred that they spent a total of over 56 million in investment, and in return, the termination led to a loss of over 980 million in investment and projected earnings. As pointed out above, Section 54(1) of the Contracts Act, Cap 284, and in the case of Patel versus Mirza, the government should not unjustifiably enrich itself and benefit from the impugned concession, which was declared unlawful by court. Moreover, the fault that led to the nullification of the concession agreement was at the instance of government. Recommendations. The committee recommends that both the petitioner and government should before a neutral arbiter reconcile the amount paid to the latter in the performance of the impugned concession agreement, as well as the cost of the investment made by the petitioner with the purpose of ensuring equity in concluding this matter. Number two, the government should compensate the petitioner all the total sum of investment and costs incurred as a result of this concession. Number three, upon payment of all the incurred costs and investments, the petitioner should be allowed, for instance, a time of 1 year from the date of payment to uninstall their infrastructure from Kilembe mines. Number four, the government should not hand over the exploration and operation of Kilembe mines to any other concessionaire prior to full payment of the reconciled amounts or the reconsideration of the claim. 7.3.2, rectifying the illegality and renegotiating the first concession. This remedy is not rooted in law, but it is based on the nature of the business engaged in by the petitioner and the intensity of capital investments and risks involved. Kalejas v. Law number 406, Unconstitutionality and Mining Concession, 2023. In this case, Law 9 of February 26, 1997 of Panama, approving the 7997 contract, was declared unconstitutional on the 21st December 2017 by the plenary session of the Supreme Court of Justice. Subsequently, negotiations between the state and the concessionaire led to the formulation of a new concession contract aimed at safeguarding employment, fostering economic growth, and ensuring the state's benefit from the resource exploitation. The new concession contract, executed as a result of negotiation, granted Minera Panama SA exclusive rights over specified zones for 20 years, starting from December 22nd, 2021. The committee observed that the concession agreement was declared by court to be unlawful because the government never sought consent of other shareholders in Kilembe Mines Limited prior to entering this concession. The petitioner had taken over possession and had started exploration process in fulfillment of their obligations under the impugned concession. Indeed, they had already started exploration of minerals. The petitioner had already spent huge sums of money and resources in setting up infrastructure in performance of the concession. The petitioner had also spent significant amount of money in paying employees, taxes, debts of Kilembe Mines Limited, and other costs incidental to the concession agreement. However, there was no return to investment recovered by the petitioner as this concession was prematurely terminated. The government has already benefited from the impugned concession agreement and can still benefit if the illegality is rectified and a fresh concession agreement is negotiated and entered into by the parties. It is more costly to government for the petitioner to decommission and abandon the mines at Kilembe Mines than to renegotiate a fresh concession between the petitioner and government and all other stakeholders in Kilembe Mines. The government has not yet entered into a fresh concession agreement with any other party as of date. It is unfair and unjust since it is fair and just that since the ground for the nullification of the impugned concession agreement can be rectified, the government should seek consent from all stakeholders and enter into a fresh concession agreement with the petitioner. And since the government has not entered into a new concession, it is cheaper to terminate an ongoing procurement process than to compensate a petitioner for the loss of investment and business. Recommendations. The committee recommends that government should consider renegotiating with the petitioner for an award of a fresh concession in respect of Kilembe Mines subject to procurement processes. Setting towards the end. Asset stripping and maintenance of Kilembe Mines. During the visit of the committee to Kilembe Mines and interaction with the management of Kilembe Mines, it was established that during the subsistence of the concession agreement, both Kilembe Mines and Tibet had counterclaims of asset stripping. The committee found that the sale of scrap by Kilembe Mines Limited was contested by Tibet until the CEO of Kilembe Mines Limited resorted to issuance of clearance notes for whatever was being taken out of the mines. In the process, various assets left the mines unaccounted for. Further, the committee established that following the termination of the concession agreement, the manner in which the petitioner was evicted was degrading and inhumane. The committee noted that the exercise was characterized by heavy security deployment, harassment, and confiscation of property belonging to the petitioner and their employees. Kilembe Mines Limited admitted to having broken into the petitioner's offices despite their absence. It therefore remains unsubstantiated as to how and who was responsible for the loss of both tangible and intangible property of the petitioner and their employees. During its interactions with both the petitioner and Kilembe Mines Limited, the committee established that 24 computers, documents, electronic data, particularly exploration data, were confiscated. Of particular interest is a report of exploration study that could not be located. The committee further established that there were 7 vehicles that belonged to the petitioner which were never handed over by Kilembe Mines Limited. Instead, 3 of them were said to have been sold, while others are in use by the officials of Kilembe Mines Limited. The committee observed that the takeover of Kilembe Mines by Kilembe Mines Limited after the termination of the concession was tainted by irregularities such as forceful eviction, harassment of the petitioner and their employees, and 2, lack of unorganized takeover after termination of the concession agreement, which caused the risk of loss of important data and property. Recommendations. The committee recommends that the respective government agencies should always ensure appropriate steps are taken while conducting takeover in circumstances such as the scenario between Kilembe Mines and Tibet after termination of the concession agreement. 7.4.2, breach of the corporate governance principles. Good corporate governance principles call for adherence to accountability, ethics, and transparency in the running of organizations and their business operations. Corporate governance principles dictate that companies have robust internal controls and systems so as to detect, prevent corrupt activities. Entities must enforce transparency at all levels and prevent financial mismanagement and abuse of public trust. The government action to unilaterally reduce the concession period from 25 to 15 years without providing an explanation and rationale undermine the concessionaires' trust and confidence in the project. The reduction from 25 to 15 years led to instability in the concessionaire's planning. Further, bureaucratic delays across various ministries contributed to the concessionaire's inability to meet timelines. As a consequence, these governance lapses hindered efficient project execution. The committee found that government and Kilembe Mines were not fair to all shareholders in the company. In this case, the administrator of Sir GDK Rukidi Estate, when they sidelined the shareholder in the decision-making process of conceding the company's assets to the petitioner, which amounted to operation contrary to the 1995 Constitution and the Companies Act. The government and Kilembe Mines were not transparent and honest to the petitioner when they concealed material information as regards to the shareholders in Kilembe Mines Limited, which they adversely affected the rights of the petitioner and resulted into the nullification of the entire concession agreement by the courts of law, hence causing financial loss to both government and the petitioner. There was never a meeting of the board members of Kilembe Mines Limited to initiate the process of divesting the rights and properties of the company, but instead it was government officials from ministries and departments that convened such meetings. Moreover, a board resolution that authorized the process of divestiture was registered after the notice calling for bids had already been published. This was submitted as evidence in the case of Gilbert Mujoga and another versus the Attorney General, and was a violation of the Companies Act. Observations. The committee observes that various government departments did not coordinate adequately, causing bureaucratic delays that frustrated the concessionaire's ability to fulfill the obligation. The government's lack of internal coordination led to the significant bureaucratic hurdles impacting the concessionaire's performance. Recommendations. The committee recommends that future concession agreements should include an explicit clause protecting initial terms from arbitrary changes in order to avoid unilateral changes in the concession terms. 2, government should establish a dedicated committee to oversee multi-departmental projects so as to enhance collaboration and reduce bureaucratic delays. 3, government should take action and discipline public servants that are found culpable in frustrating investors and government projects. 3, government should clearly define the role of Kilembe Mines Limited to avoid conflicts pertaining operations of the divested mines with the concessionaires. Number 5, that the Office of the Inspectorate of Government should investigate individuals who were involved in facilitating the wrongdoings in the concession agreement and take appropriate action. Number 6, the Committee of Public Accounts, statutory authorities and state enterprises should investigate the activities of Kilembe Mines Limited in respect to the operations, management, and custodial responsibility over Kilembe Mines. 7.4.3, absence of neutral party to carry out supervision of the concession. Corporate governance requires that for companies to be accountable and transparent in their operations. This includes disclosing potential conflicts of interest and ensuring stakeholders, including shareholders, customers, and employees are treated fairly. The committee established that the concession agreement did not provide for a neutral party to supervise and monitor the performance on the concession. The committee observed that the absence of a neutral party created communication challenges between government entities and the petitioner. Consequently, this meant that the ministers were directly dealing with the concessionaire, which communication was not timely and also short of the requisite technical know-how. Recommendation. The committee recommends that the government should, as a matter of policy, appoint a neutral and technical person to oversee and supervise agreements, contracts, and concessions where the government is a party, such as the case of Engineer Dr. Badru Chigundu with the Isimba hydropower project. Presence of freshly harvested timber in Kilembe Mines. During its visit to Kilembe Mines, the committee sought clarification regarding the freshly harvested stockpiles of timber at the site. Kilembe Mines Limited explained that the timber was intended for renovation, operation, and maintenance of the mines. Despite these claims, there was no evidence of any ongoing renovation work at the mines, raising concerns about the actual purpose of the harvested timber. The committee observed that the unexplained presence of freshly harvested timber on site, with insufficient justification for its intended use, suggests possible misappropriation for illegal commercial purposes by Kilembe Mines Limited. The committee recommends that the offices of the Auditor General and the Inspector of Government should carry out a forensic audit of the natural, fixed, and movable assets of Kilembe Mines. Flooding of River Nyamwamba. The committee takes cognizance of the fact that River Nyamwamba, which runs through Kilembe Mines, is prone to flooding. The committee notes that the floods that occurred in May 2014, for instance, had an effect in disrupting the work in the mines, and the petitioner cited the floods as part of the reasons that hampered their operations, causing difficulty in delivering the planned activities. The impact of mining activities at Kilembe Mines poses serious risks such as destabilization and collapse of river banks, which exacerbate the river's susceptibility to damage and contributing to environmental degradation. The committee observed that the fact that the river is susceptible to flooding means, regardless of who the concessionaire is, there is always a likelihood of work being disrupted and livelihoods in the area being severely affected. Besides disrupting work in the mines, the floods have caused expansion of the river banks and in turn causing some of the roads that serve the reducing some of the roads that serve the area. Recommendations. The committee recommends that Government of Uganda should establish and enforce comprehensive environmental protection measures tailored to safeguard River Nyamwamba and its surrounding ecosystems, especially given the heightened vulnerability and frequent flooding. Number two, future concessions should embed stringent and enforceable commitments to sustainable practices that actively mitigate the risks. This may include implementation of advanced ecosystems, control techniques, habitat restoration projects, and continuous monitoring to prevent detrimental impact of the river's structural integrity. Three, establish strict oversight and proactive measures that are essential to protect River Nyamwamba, to prevent further ecological harm and preserve the livelihood of the communities that rely on its health. Alternative mining investment opportunity. Uganda presents various mining opportunities. Uganda has been keen to promote private sector participation given the favorable geological conditions that present compelling opportunities for both domestic and foreign investors looking into invest in the mining sector. Uganda is also endowed with various minerals, including but not limited to rare earth elements like iron ore, gold, limestone, phosphates, among others. According to the NDP3, there is limited mineral exploitation, development, and value addition due to some of the reasons are there. I got straight to the observation. The committee observed that given the financial and technical potential of Tibet, it is prudent that government takes advantage of their willingness to invest in Uganda, which would contribute to the realization of NDP3. The committee recommends that government should enhance strategies to attract, protect, and incentivize investors across various sectors for socio-economic transformation. Encroachment of Kilembe mines. During the investigation, the committee was informed that while government had handed over Kilembe mines to the petitioner, as obliged under the concession, there are various challenges of encroachment on the mining area by squatters and developers. The committee observed that encroachment poses a danger as it impedes operations of the mines. Recommendation. The committee recommends that government should take measures to ensure that the land belonging to Kilembe mines is protected from encroachers and that encroachers are evicted in accordance with the law. 7.4.8, duration for which Kilembe mines had not been operational prior to concession. The committee noted that Kilembe Mines Limited had not been operational for over 30 years prior to 2013. And this, therefore, posed unique challenges to the concessionaire since the mine required significant capital and technical resources to revamp its operations. Most of the machinery, equipment, and installations had become obsolete and collapsed, which also required time. The committee observed that the necessity of time, heavy capital investment, and specialized technical input should have been considered in evaluating the performance on the concession agreement. The committee recommends that the government takes into consideration such circumstances when entering into concessions of this nature. Commitments to international obligations, international relations, and diplomatic undertakings. The committee recognizes that it is critical for government and its officials to remain sensitive to issues regarding international relations, diplomacy, and multinational cooperation, while advertising, contracting, and executing agreements with foreign of such magnitude. The committee observed that the unfair termination of the concession agreement between the government of Uganda and the petitioner could cause unnecessary diplomatic tension between the government of Uganda and the People's Republic of China. The committee recommends that it is essential for government to formally integrate consultations with the embassies of or diplomatic missions of countries from which concessionaires originate as part of the due diligence process. This approach ensures that information provided by prospective bidders is accurate and transparent. It also facilitates a cooperative international framework. This fosters trust and good bilateral relations. Honorable colleagues, the unique nature of concession agreements in the extractive industry. The committee takes cognizance of the unique, risky, and capital-intensive nature of such concession. This dictates that sufficient reasonable timelines should be allocated to the various phases of bidding, procurement, processes, contracting, and actual performance of the concession. Further, it is important for concession agreements in the extractive industries to include aspects of decommissioning, given the huge impact such ventures have in the environment. The committee observed that the concession agreement did not provide for mechanisms of decommissioning. Recommendation. The committee recommends that the government should elaborately provide for decommissioning mechanisms and procedures for all other concession agreements, such as this, to protect the environment and human health. Oh, okay. 7.4.11, the proceedings of the Winding Up Commission. The committee noted that whereas the concession agreement provided that the Winding Up Commission would be set up in the event of its termination, this was done as soon as the notice was issued before the lapse of termination. The committee notes that the appointment of a Winding Up Commission prior to the lapse of the notice of termination created impression of a predetermined conclusion that no amount of interventions would cure the defaults for which the termination notice had been issued. What is worth noting is that the notice of termination was issued on the 20th of June, 2017. It took effect on the 5th of July, 2017, and it was supposed to last for a total of 60 days. However, within the same month of June, a Winding Up Commission, which should have been appointed after the termination has taken effect, had already been put in place. The hurried appointment of the Winding Up Commission pointed to a rush with which Honorable Evelyn Anite conducted the affairs of this important and strategic project. Recommendation. I said honorable. Okay. The committee recommends that the Honorable Minister for State Finance and Economic Development in charge of investment and privatization is held liable and is cautioned for not following due process resulting into the untold loss to government and the petitioner. 2, government officials that cause similar losses to government should be held personally liable for their actions, inactions, and omissions. Number 3, relevant ministries and agencies should always be prudent and exercise the highest degree of diligence when performing contracts and making decisions on behalf of government. 7.4.12, payment for energy generated from Mubuku 1 hydropower project. In terms of financial commitments, the Uganda Electricity Transmission Company Limited met its obligations to pay Tibet for the energy generated from the Mubuku hydropower station. Payments totaling to 7.9 billion were made to Tibet. This underscored the government's adherence to the financial agreement within the scope of the concession. The committee observed that although the payments provided a steady revenue stream, Tibet's broader operational challenges limited the impact of these funds on their overall project viability. Recommendations. The committee recommends that before granting any concessions and contracts, government should carry out due diligence as a matter of national responsibility. 2, the committee recommends that government must resolve all outstanding claims upfront so that any concessionaire investing in Uganda does so with clarity, confidence, and free from legal entanglements that could jeopardize the progress of the projects. In conclusion, Right Honorable Speaker, Honorable colleagues, the committee's comprehensive review and investigation of the petition by Tibet-Hima Mining Company Limited has revealed significant procedural coordination and governance lapses before, during, and after the execution of the concession agreement. These systematic failures served to undermine the integrity and validity of the concession agreement. Needless to say, The nullification of the concession agreement was not an isolated failure, but a culmination of factors such as lack of dutifulness and prudence by public officials, conflict of interest, collusion, and insufficient interdepartmental coordination, among others. It is therefore the contention of the committee that strategic government projects such as this should call for deliberate effort to set up technical and administrative mechanisms for their effective initiation, implementation, and performance evaluation. The committee reiterates the importance of supervising performance of agreements relating to the country's natural resources to ensure maximum benefits. Right Honorable Speaker and Honorable colleagues, I beg to submit. I thank you for your kind attention.
Thank you so much. Your report?
Right Honorable Speaker, by the committee.
Okay. Thank you so much, Honorable Anite. Honorable Anite with the E. Procedure matter.
The report has mentioned the Office of the Attorney General here. On number 2, the Office of Attorney General was not consulted when the concession agreement was being cancelled or a notice was being issued. And secondly, regarding the decision on the fact that actually the court ruled that the concession agreement in the first place was actually null and void. So would it be procedure right that we allow the Attorney General to first clarify on those allegations that the office, well, his office was not involved in during the cancellation of this concession agreement, so that it guides the House on how we can proceed as well? Thank you.
Right Honourable Speaker, it is an interesting question because I was not Attorney General at the time, and I think the right person to ask should be the Honourable Minister, whether she consulted the Attorney General. Thank you.
Anita
With the A.
I am very honored to be given the opportunity to come and speak about Tibet-Hima, the automobile limited company. But perhaps before I say much, I want to welcome the committee from their fruitful trip from China. I could see that it was wonderful, and it is reflected in their minutes.
What's
the order for?
They went. Yes.
I'm welcoming you. Didn't you go?
Thank you, Right Honourable Speaker, that a committee has a right to go for benchmarking. When you begin with that, there is a motive you want to impute. So is it in order for the minister, when he's supposed to begin with the material, to begin with the immaterial, to impute a motive as if there is something that was behind that? Is it in order?
Honorable Minister, the committees have a right to go for benchmarking wherever they want to go. And it is out of benchmarking that they will be able to find out what went wrong and what did not go well. That is that.
Madam Speaker, you're very...
Minister by her name, Honorable Anite and Okasai. I'm standing to be corrected. Were they acting in their personal capacity or as ministers in charge of privatization? If they were acting as ministers, isn't it prudent that the committee amends the report to refer to them as the ministers in charge of privatization, not in their own names? Thank you, Madam Speaker.
Right Honourable Speaker, the committee takes cognizance of the observation of the Honourable Enos, and first and foremost, in the case of probably the Honourable Minister of State for Energy, we probably want to think we will say Parliament is right to request that that is concealed. But in the case of the Honourable Minister for State for Finance, she told us, I took a personal decision. We have it in video because it was recorded in the... I took a personal decision, and I don't mind if I am going to be sacked over this. let me, as Evelyn Anite, be sacked. It would have been wrong for us not to take her own plea of being quoted as
clarification here. Truly speaking, that the minister took personal responsibility to an extent of even wishing to be sacked because of her opinion and decision. Because ministers carry political responsibility of the ministry. If that is what she said, that is grave. The fact, if she said that, my sister, whom I know, let me leave that comment because
Honorable Member of State for Investment is Honorable Anite. And it's a very simple thing. Just to say, Honorable Anite, the Minister of State for Investment. Because when you look at Article 117, it says ministers shall individually be accountable to the President for the administration of their ministries and collectively be responsible for the decisions made by Cabinet. So it is Honorable Anite, the Minister of Investment. Honorable Kasai, the Minister of State for what? Energy. Okay.
Coming the committee back from China. And indeed, the committee went to China. There were no accidents. They came back. They reported to this house, and I listened that they went to China and they came back. So I am just in order to say welcome back from China, unless they're denying that they didn't go to China.
I did approve the travel for benchmarking.
Thank you, Madam
So it was not anything illegal.
Madam Speaker, I'm not saying it's illegal. In fact, I would therefore want to add you in the list to congratulate you upon sending them to China. They did a good job.
No, you don't have to add me in the list, Madam.
So, Madam Speaker.
Honorable Anite. Yes. Honorable Anite. Honorable Anite. Yes. Yes, Emmanuel.
Madam Speaker, at the prompting of the Deputy Attorney General, because somebody had asked a question about the role of the Attorney General because of the statements which came from the committee. And the Deputy Attorney General got up and stated that the person who is supposed to answer that question is Anite. And I thought for now, we are not yet looking at any other thing. She is supposed to answer that specific point about whether they consulted the Attorney General or not. So we don't need to go into other things for now. Thank you, Right Honorable Speaker.
Answer the question. Don't be hyper. I know me and you, we can be at the worst, but for now, be calm.
The Attorney General at the time. And
okay, that's exactly.
I do have my evidence.
A clarification from the lawyer.
Before he does ask me the clarification, I need to submit further. That I actually consulted the Attorney General, and I will bring the evidence here. And if you allow me to continue with my submission, I will tell you the legal proceedings that I followed.
Honorable Anite, it basically needs a clarification.
UCMP. When somebody seeks clarification, that means I've not understood what you are submitting. My clarification, you are referring to have consulted the Honorable Minister, who is the Attorney General. Attorney General is, you seek his legal opinion through writing. Can you lay on table? Can you lay on table the letter you wrote to the Attorney General seeking his opinion on this particular matter?
Thank you.
And his response.
Thank you.
Information. Sought clarification. Sorry. Sought clarification.
No, it is all correct. It is all correct. Don't mind. You
sought clarification from the Attorney General.
She thought, yes.
Yes, but what I wanted to clarify is that there was an engagement between the Minister of State for Investment and actually the committee. I wanted the chair to come out and inform us whether they actually requested for that written document at that time, and was it actually laid at the time? Because if there was that time of engagement, why is it that it was not laid at that time when they actually had the communication with the committee?
You see, if they did not ask at that time,
that's what.
This is a house of record. This is a house of record where we want evidence-based.
Madam Speaker, I am happy that that presentation of the committee, or that hearing of the committee had media. Right Honorable Speaker, there are two issues regarding that matter. One was on whether or not the minister sought the advice of the Attorney General.
No. Panadol is
okay.
Panadol is dreaming.
Right.
Can you continue? Continue. We are getting out of time.
Right Honorable Speaker, may I clarify the question of Honorable Otimgil is to me. The committee asked the minister that question. And the Honorable Minister on that day said all the line ministers are aware. The Minister of Energy and the Attorney General are all aware of the actions she took. The Land Attorney General came on a different date, and we asked the same question. He said, I was not consulted, but in any case, the minister is not obligated to ask me. There are many things that go on in many ministries. Must each of the ministers keep asking me, Attorney General, should I do this? So, she did not have to ask me. She didn't ask me. Number two, there was the issue, because there is the issue of evidence here. There was a second issue where the minister said that the president ordered them to terminate the concession. We asked her, can you give us evidence of the president's directive? She told us, you know how the president works. He calls people in a meeting, we're just in a meeting, and said, I'm tired of these people, terminate. I have members in my committee who can substantiate. I thank you.
Madam Speaker, is the chairperson of the Committee of Natural Resources in order to put words in my mouth when the proceedings of the committee sitting were recorded. When the committee asked me how I arrived at issuing the termination, I gave them a history, detailed background of the events that unfolded. My first point of reference was a State of Nation address made by the President of the Republic of Uganda, where he made reference, and at the time I was the Minister for Youth, he made reference to the extent that the then ministers responsible for this docket were corrupt and hired, actually concessioned, a quack investor who came here to make motorcycles and gave them this, and he was going to deal with it. And to my surprise, let me finish, I am on order, To my surprise, that happened in 2015. To my surprise, in 2016, my predecessor was relieved of his duty and I was appointed. And when I was appointed, the President of the Republic of Uganda in cabinet again said that the concession of Tibet-Hima should be terminated. And following that discussion in Cabinet and the directive of the President in Cabinet, before I could even take a step as the minister responsible for investment and privatization, this very parliament called me, summoned me in this house, and demanded for termination of the concession of Tibet-Hima, the automobile. I then went back, brought report to this house, to the mismanagement of Kilembe mines by Tibet-Hima, and I gave them my word that I will surely terminate the concession following the legal proceedings. Right, Honorable Speaker, and dear honorable colleagues. And then I went back, followed the law to the letter, consulted the Attorney General. The concession agreement empowered me not only to terminate the concession by myself unilaterally, but to constitute a winding up commission. And I constituted a winding up commission on the 5th of July 2017, constituted it, and the winding up commission comprised of 6 members, 3 of them from government, 3 from the concessionaire Tibet-Hima Automobile. And I laid all this on table. And therefore, is the chairperson of the Natural Resources Committee in order to impute and lie when I was actually serving the country?
I have clarification. Chair, you need to clarify this.
Honorable members.
The chair needs
I
to clarify.
thought it was an order. Honorable members, the Minister of Investment and the Minister, and the Chair of Natural Resources, don't drag me into making a decision on where I don't have evidence laid on table. If you're talking, if anybody is saying, I was told to do this, lay evidence on table. If there was a cabinet, lay on table. There was ABC, I want it on table, I will not make a decision. I will not say whether you are in order or whether the other one is not in order, because you don't have documentary evidence, and I will not be dragged into that debate. Yes, Council.
Thank you very much, Madam Speaker and Honorable Colleagues. Make statements or remarks on the recommendations of the Committee of Natural Resources. Allow me, in brief, just give you a summary, executive summary, of how the Winding Up Commission that I constituted and came up with the conclusion of terminating the concession of Tibet-Hima Automobile. This report contains the background to the Kilembe Mines concession and documents that silent issues arising in the report of the concession, the performance or non-performance of the key concession obligations, and the recommendations of the Kilembe Mines Winding Up Commission. The committee was appointed by myself, Honorable Anite Evelyn, the Minister of State for Finance in charge of investment and privatization, and the committee commenced its work on the 5th July 2017. And I did give the House the background to which I arrived at this point of constituting the commission, the Winding Up Commission. The Winding Up Commission was established by the virtue of the express provisions of the concession agreement entered into by and between the government of the Republic of Uganda, Kilembe Mines Limited, and Tibet-Hima Mining Co. Limited, the concessionaire. The establishment of the Winding Up Commission was done as a result of government of Uganda having issued a notice of termination of concession agreement referred to above, and which termination notice save for a cure of event, which expire on 5th day of September 2017. Right Honorable Speaker and honorable colleagues, I gave you a background of how I arrived at this point, because I was prompted by, first of all, the President of the Republic of Uganda in Cabinet and through public address in Serena, Kampala, and this House. Under the terms of the concession agreement, the concessionaire was required within 30 days of the establishment of the Winding Up Commission to present to the Winding Up Commission a summary report on the status of operation as the date of termination notice, and to present a final report 60 days after the establishment of the Winding Up Commission. I emphasize the 60 days. The concession agreement then required the Winding Up Commission to deliberate and recommend to the government of Uganda whether the concession and the concessionaire should seek to transfer the assets and operations to their third party or render for the potential of full cessation of operations and disposition of assets in accordance with the terms of concession agreement. The Winding Up Commission identified 4 key areas in respect of which they required the concessionaire to address them. The concessionaire was required to inform the Winding Up Commission what the status of operations at Kilembe Mines was at the date of termination, the expectations and deliverables under the concession agreement, and what had been achieved, any challenges faced by the concessionaire, and lastly, the strategies the concessionaire had for fulfillment of the concession obligations. The Winding Up Commission held several detailed meetings over a period span close to 4 months while implementing its mandate. So, Madam Speaker and honorable colleagues, I need to pause there a little bit and just inform that the spirit in which the committee reported that we didn't give them time, I didn't do that, I didn't do the other, is wrong, because even then it took 4 months for us, just for the both concessionaire and government to try to make good of the concession within the winding up period. The concessionaire, upon prompting of the commission, presented a draft report and a summary report on account of the voluminous nature of the information that had been provided during the concession meetings and engagements. The concessionaire never provided a final report, but requested the Winding Up Commission to consider the summary report and the documentation provided as constituted its final report. The Winding Up Commission then deliberated, obtained Chinese translation of its report from the benefits of the concessionaire, and made its recommendations as contained in detail in the body of this report. And Right Honorable Speaker and honorable colleagues, this report actually, I submitted it to the to the Committee of Natural Resources. I expected them to be nationalists and present this to the House, but to my dismay, welcome back from China. The Winding Up Commission, in the course of its duties, engaged with the concessionaire representatives of the government of Uganda, key stakeholders would include, among others, the Uganda Electricity Transmission Company.
Anite, there is an order from...
Thank you, Right Honorable Speaker. I would like to implore you to help us understand the conduct of this minister on this floor and making statements that really demean the committee and members of this House. Is she really in order to continue making such statements in front of all of us? I thank you.
Honorable Minister, as I said, tone down. Have respect for yourself, for the committee, for members of parliament, and finally for the speaker, if she deserves respect.
Thank you, Right Honorable Speaker, most obliged. The Winding Up Commission then deliberated and obtained Chinese translation of its report for the benefit of the concession and made its recommendations as contained in the detail in the body of the report, this report. The Winding Up Commission, in the course of its duties, engaged with the concessionaire representatives of the government of Uganda, key stakeholders who included, among others, the Uganda Electricity Transmission Company Limited, the National Environment Management Authority, the Electricity Regulatory Authority, subcontractors, partners, and agents. In general, the Winding Up Commission established that the concessionaire had carried out some investments at the Kilembe mines, particularly at the mill, in fabricating trolleys and repairing the rail track and the foundry. The concessionaire was, however, unable to provide the Winding Up Commission a physical justify.
There's a procedure matter.
Honorable colleagues, I'm just becoming impatient. The honorable member, right honorable speaker, the chairperson presented the report. I expected the honorable minister to respond to the report.
Issue by issue.
And I'm only seeing her reading a report. Maybe for avoidance of doubt, if I saw, this is, the report on the Kilembe Mines Winding Up Commission of October 2017. 2017, a member is has just presented a live report of today. And you are reading for us things that were done in 2017. And for us, you have space to waste all our time when issues are just too many for you to respond to. Is that procedure right, Honorable Speaker, for the Honorable Minister?
Another procedure. I'll rule on
Madam
all of
Speaker,
them.
basing on the procedural matter submitted by Honorable Teka Simire. But Madam Speaker, really would like you to call, I would like to call my sister to be calm. Let me use that language from Sia border. I know, Madam Speaker, always, my brother has a problem with the English language, but my sister, I want you to be calm. And I want you to make our time here very useful. Because truly speaking, the chairman of the committee read the report, and the report had issues. You make much of Busia to look a fool if you begin reading a report of a long time ago, not basing on the submission of the chairperson. The fact I'm one of the people who are confused whether you are doing it whether you are doing the right thing at the right time. I therefore request you, my sister, that why don't you strictly stick to the report of the committee to make us follow well so that we find a solution to this matter. Secondly, Madam Speaker, I request diagram from the minister, because the way you are submitting, you look as if you're on tension, you look as if they are chasing you, you look as if you have fear, you look as if you had conflict of interest, and this lady of Noop supports you. When I talk,
honorable members,
don't talk.
Honorable
Madam
members,
Speaker, this lady should stop intimidating me.
She's on
That is domestic violence to a man like me.
He's
no,
on
stop harassing
procedure.
me.
He's
Stop,
on
stop to
procedure.
harass me.
Listen.
Whenever I'm submitting, the lady is harassing me. Excuse me.
Who is attacking?
The honorable member should stop harassing me.
Let me tell you people,
I
don't
know.
put your personal feelings into this.
Sure,
report.
this is a very important matter.
You get it, eh?
Huh?
We are the same people who are saying we want investors in the country. And if there is a mistake that has been made, we correct it. If it is the investors who have made a mistake, then they should be obliged to correct it. Let's look at all this with merit. Yes, let me hear from council. Let me hear from council.
Madam Speaker, I'm raising on a point of procedure once again.
Senior counsel.
And I don't know whether it is right for me to...
Senior counsel.
There's a senior one here. Okay.
Thank you very much, Right Honorable Speaker.
the Honorable Stephen Baker had forgotten that I agreed to be answered before we proceed. And you had started addressing your mind to this fundamental threshold question. The threshold question is, did the Honorable Minister of State for Investment seek and get the opinion of the Attorney General before revoking the concession agreement? That is a constitutional question. Before we consider anything, we ought to see evidence that the Attorney General issued an opinion in writing. Why am I saying that, Right Honorable Speaker? Right Honorable Speaker, wait. Right Honorable Speaker, I have addressed my mind to Article 119(5) of the Constitution. And if you permit me, I will read it verbatim. Subject to the provisions of the Constitution, no agreement, contract, treaty, convention, or document by whatever name called, or document by Right Honorable Speaker, for the benefit of my beloved sister, the Honorable Anite, I was reading verbatim the contents of Article 119(5) of the Constitution. Subject to the provisions of this Constitution, no agreement, contract, treaty, convention, or document by whatever name called, emphasis mine, document by whatever name called, to which the government is a party or in respect of which the government has an interest, shall be concluded without the legal advice of the Attorney General. Shall be concluded without the advice of the Attorney General. Now, Right Honorable Speaker, we are talking about a subsisting contract and the termination of that contract by a document called the termination letter. That could never have happened without the express advice or opinion of the Attorney General. So before we consider any other matter, we need to be convinced by way of evidence that the Honorable Minister procured the opinion of the Attorney General, and she only proceeded in conformity with the opinion of the Attorney General. I beg to submit, Right Honorable.
Thank you, the Attorney General.
Madam Speaker, Madam Speaker, the agreement the concession agreement that we're talking about was written by the Attorney General, and the powers for terminating the concession were enshrined in the termination agreement. And I just mentioned that I followed the procedure which is spelled out or laid out in the concession agreement. And Honorable Tinka Kasimire
is drafting the agreement
it's not drafting.
The same as seeking for a legal opinion?
No. If the law is in your hands, the agreement is spelled out. How you enter into the concession and how you terminate the concession. The proceedings are all written down. And I followed the procedures. And Right Honorable Speaker, I will also come back to the House with the report and the names of nominees from the Attorney General to show to you that I actually consulted them and the Attorney General was fully involved in the winding up of Tibet-Hima. And I will bring that to the House.
Thank you,
There's a procedure matter.
Thank you, Madam Speaker. 1st of October 2024, the Attorney General provided written response indicating the termination of the concession agreement was in accordance with the terms of the concession. Doesn't that imply that he was in agreement with the process?
Some procedural issue. You had made a valid observation that we need investors, But also we don't need the quack investors. We need investors who can help us and do the right thing, make us to grow. There are situations where you find investors come after exploiting our avenues of benefit, tax benefit. After 10 years, they change names, they change situations. Some say for us, this is not a lucrative venture. We want to close and go. And actually, the same people also come back in different names. Now, when you look at the report being presented by the committee and the issues they have raised, some of them are issues which touch on the minister. And the way I look at the whole things, there are a number of documents which are supposed to be presented as evidence. So my consultation, my view is, we want it to be procedural right, that we give this minister time, reads these documents, and back her submission with the documentary evidence that she has talked about, so that we have a balanced debate based on response, which is also backed by what? By evidence. Because as we look at the whole thing now, if we rush and debate, and yet she says some of these documents are still left behind, I don't think we might be fair in our debate and a balanced debate. So I was just seeking your opinion. Thank you, Madam Speaker.
You have evidence. You have evidence that you want to lay on the table?
Madam Speaker, I can just bring additional information because my conscience is very clear that what I did was for the good of my country, and I stand with it. I can debate this anytime, any day. And therefore, if you give me the chance to respond to, to the report, recommendation by recommendation, even now, I'm ready.
Go ahead. Let's get responses from the minister.
That concern me as the minister responsible, that is issuing notice of termination and then formation of the Winding Up Commission if I did it in accordance with the law. The honorable colleague there has, my honorable colleague, Honorable Enos, has actually made reference to the committee's admission of the fact that the Attorney General said I did consult, and that therefore rests that particular point. I therefore would like to make reference to point 26 and page 26 and point number 3. Point number 3, having rested the point that whether I consulted or did not consult, I actually did consult, and it has been confirmed in the committee report. And I still want to confirm that I consulted and followed the concession agreement that was written by the Land Attorney General. Now, recommendation number 3 says, Honorable Anite Evelyn should take political responsibility for her involvement in the misfairness regarding the performance and the unfair termination of the concession agreement and consider resigning as a minister. My response to this is that I shall not resign even when I have gained enough capacity to be a private citizen, but I am not going to resign because I did the right thing for the just cause of the country.
We could make a correction on that, not taking a political responsibility, because it was collective responsibility, not taking a political responsibility. It was a collective responsibility under Article 117.
Thank you, Right Honorable Speaker. Right Honorable Speaker, just to back and justify why I am the most competent minister for that ministry, is that...
That one has been sorted.
Thank you. I just wanted to bring out this point, that Tibet-Hima, Right Honorable Speaker, I speak as a citizen, and it really touched me so much and to the level of actually angering me. The fact that Tibet-Hima, in the Winding Up Commission, no, it's not to do with this, I'm bringing another point, that they our point of departure with Tibet-Hima as government of Uganda and is the fact that they wanted 30,000, and they put this in writing, 30,000, and it's here in this report, 30,000 metric tons of copper concentrates, which combine of gold, copper, 30,000 tons. Right, Honorable Speaker, you're a businesswoman. You know how much 1 ton only weighs. 1 ton. But these guys, as a competent businesswoman that I know, you will understand what these people were trying to do. Fleece the government of Uganda and the people of Uganda of their natural resources. I actually expected to be given a medal by the committee for saving government of Uganda and the citizens of this country from robbery of 30,000 minerals of the people of Uganda. This is the future of our citizens. I came at a point.
There's a clarification somebody wants.
I came at a point.
Thank you, Right Honourable Speaker. In the same spirit, Madam Medal for saving Uganda, the report of the committee said, after rejecting the 30,000 they had requested, you didn't respond whether you were giving them 1 or 10 or 5. So we wanted to know from your office, which kilograms were you ready to give, and why didn't you give them the one you felt could be sufficient for them to do the testing?
Right Honourable Speaker. Right Honourable Speaker, the Minister in charge of Energy and Minerals will tell you under our Mineral or Mining Act how much quantity is required to be taken out of the country as samples. And she would surely come to this House and respond. But the truth is, even because I don't want to do her job, she will respond and tell us the quantities. But to just answer him directly, Right Honourable Speaker, the committee makes reference of the meetings and the intervention of General Salim Saleh. All these were meetings that we had in the office. And I held these meetings together with the President in State House, and the rejection and telling them that they cannot take 30,000 tons was done by not myself, but by the President of the Republic of Uganda, President Yoweri Kaguta Museveni, in my presence and in the presence of the investors. So they cannot say we did not give them a feedback of whether they can take the 30,000 metric tons. Right Honourable Speaker, 30,000. Right Honourable Speaker, I've gone through the entire report. There were only 2 issues that concerned me. One is whether I actually acted in accordance with the law, and I thank you for responding to that. The other is that if I didn't act according to the law, I should take a political or whatever responsibility. I have answered it. I am a very proud and happy citizen that I did my job and terminated the concession of Kilembe mines.
Thank you. Honourable
Speaker, I just want to seek clarification from the Minister, because she just stated here that the company, why she cancelled the agreement was because the company was exploiting our resources. I just want to seek clarification from you, Honourable Minister. When you are asking money from these people, $6 million, you didn't know that these people were going to exploit our resources? You first get my money, and then after you cancel the agreement. When I say I want you to refund my money, you give an excuse that we realize that you want to exploit our resources. Why did you take their money when you knew that these people were going to exploit our resources? Or else, after discovering that these people were exploiting our resources, why didn't you refund their money?
Maybe the question would be, what was the 6.6 billion meant for?
Debates that are intriguing. There seem to be interesting sides. Here there are those who went to China, there are those who didn't go to China. The minister is telling us she did a job good enough on behalf of the country.
The committee is also saying they're working for the good of the country. The lawyer in me is intrigued by something on page 23 of the report. And this is a procedural issue that I'm raising. There's a civil suit number 116 of 2018, Tibet-Hima versus Attorney General and Kilembe Mines. So Tibet-Hima went to court challenging the termination of its concession. This, and I'm actually quoting the committee report, the petition by Tibet-Hima was dismissed by court because they were challenging the termination of their concession, so it was dismissed on grounds that it should first be referred to arbitration. Procedurally, I'm interested. I'm really concerned about the legal matter, yeah? Aside from who saved what and that kind of thing, that all can be conjecture. But the law, which I'm concerned about, there's a court matter. There was a verdict of court. Court dismissed this petition and said go to arbitration. Can we be updated? What happened? How far, if at all, did the arbitration go? Because we might be here, have pettifogging over this and the other and so on. I'm very interested in this legal matter because it might help us with many things. There was a court petition. Tibet went to court challenging its termination, the termination of its concession. Court dismissed their petition and said go for arbitration. So court paved a way that should have been followed. Was that followed? If not, why? Because it will help us and probably avoid even the back and forth that we are having.
Thank you, Right Honourable Speaker. I appreciate the issue raised by the Leader of Opposition. It is true, Tibet-Hima went to court, and their suit was dismissed, specifically for the reason that the concession upon which they were basing their suit had a proviso that any dispute relating to the concession should be taken for arbitration first. So they had not taken the matter for arbitration and instead gone to court. And court said, no, you do not have jurisdiction here. Your first instance should be arbitration as long as the concession is the one on which you are basing your suit. That's the reason as to why it was dismissed.
Thank you. Thank you.
So court provided a remedy, as far as I'm concerned. And I'm interested in establishing whether that remedy was explored. Because also, Right Honourable Speaker, and as one of the colleagues did raise, many times you have dissuaded us from debating matters that either are in court or that have been determined by court. Because if a court determines a matter, Parliament cannot undo it. So the legal guidance I'm giving, and there are many more senior lawyers than myself here, but it's important that we cover ourselves legally. I want to dissuade us, whether it be from, and it doesn't matter who you are for. In fact, for me, I'm for Uganda. That's why I want to know who did wrong and how it gets to be determined. So I'm not going to say I am for Tibet or I am for the decision taken by the minister. All of that, for now, as far as I'm concerned, is conjecture that does not help us. Court provided a remedy and said go and do arbitration.
Information law.
We need an update.
There's an information
on whether or not arbitration was done, that go and do arbitration. You are meant to give a report back to court, because court gave its guidance. So how did this matter end? My colleague wanted to give information.
Yeah.
Senior lawyer.
Thank you very much, Right Honorable Speaker, and thank you, Lord, for yielding the floor. There's no court order to go to arbitration. The suit was dismissed, and dismissed on the grounds that there was an arbitration clause. The parties were bound to go to arbitration in the first place. But the critical information I wanted to give you, Lord, is in respect of matters legal. When you are a subject of arbitration and you elect to go to court, the prevailing position of the law is that you have abandoned your right to go to arbitration.
Thank you for that information. In 30 seconds.
Let me hear from Attorney General.
Honorable, allow me just 30 seconds, since he gave me information. I want to appreciate Senior Counsel for the information he has provided. Through you, Right Honorable, I don't know that would be the Attorney General or Senior Counsel who has provided that to guide the House further. So you have abandoned arbitration, which is provided for in the concession agreement. You have gone to court. Court has dismissed your suit. What is your remedy? Because I want to be sure that Parliament is the remedy. Because also, as we are determining this matter, regardless who, court was involved. So if court is saying, I am dismissing your suit, you should have gone for arbitration. Did it happen? Because that's an option that they did not explore at the first instance. What is the latest update, AG?
Yes.
Thank you very much. Perhaps
Honorable members, stop just shouting that we are bad. That's why we accommodate petitions.
I'm glad, Right Honourable Speaker, I'm glad Lope has brought it out the way he has. Now, allow me use his position to clarify. I want you to understand, when the report was read and presented, they talked of suits that were dismissed, okay? But there was also a suit that succeeded. The suit that succeeded is a suit of Gilbert Mujogia, a son of the King of Toro, who was a shareholder in Kilembe, who was not consulted or involved in the negotiation of the concession. He woke up one day only to realize Tibet-Hima and the government had entered the concession, and yet he was a part owner of the mine who was not consulted. So he challenged that in court. And on the basis of his challenge, court nullified,
page 28.
Yes, court nullified the concession. Meaning that whether they had gone for arbitration, whether Anite had cancelled or not, the concession was a nullity ab initio, in as far as it did not involve the shareholder. So that's what informs the decision of Tibet to go for a petition. Okay?
Yes.
Because there is no concession on which they can base.
Honourable members, listen.
There is no concession on which they can found an action. So the last resort is a petition. That's why they are here. If you are not clear, let me explain again. And because it was wrong from the start, government is the one that invited Chilembe and gave them a concession, which later turned out to be non-existent. Remember, they had already paid and committed their finances, resources, time, and money. So they choose to come here with a petition. You make a decision as Parliament.
As whether they should be given a compensation whether they should be
Council
returned their money.
allowed-
Just a minute. The petitioners have come here because you cancelled the concession. And they are saying, you cannot cancel the concession and again take away the money. That is what the petitioners have come to say here. So we have to decide as a country, should we defraud the investors? Is that what we are trying to do?
Thank you, Right Honourable Speaker. The AG tried to insist on this matter is because we must, all of us, cover ourselves legally. That's very important. Honourable Speaker, severally you have told us that whether it be motions, whether it be reports that we adopt, and you are right, legally, in this House, are only advisory to government. So, whenever it is a motion that we pass, if it is a report or whatever the case might be.
A report to the bill.
Come again?
A report to the bill.
To the bill?
Yes.
Yeah, even a report to a bill is advisory. It is a bill, once it has been passed, that's a different matter. But all of these reports, petitions, and eventually, when we pass it, for as long as it is not law, it is only advisory to government.
It's true.
And for me, I am thinking we must find a legal remedy so that government, even if we eventually pass whatever we pass here, tomorrow they say, well, it was just advisory, they choose to do something else. And that's where, I don't know where the AG has gone, so that I've seen him. So that, that's the clarification I'm seeking for from the AG to see how he guides government and ourselves for something proper legally. That's the further clarification. This is for lawyers, Honorable Sirwani. Senior counsel, the Attorney General, let me finish my clarification to senior counsel. Calm down. It's okay when I say you're not a lawyer. It's okay. Even me, I'm not a doctor. I'm not an engineer. I'm a lawyer. It's not an offense.
Honorable Solomon, but you did history.
Yeah, it's okay. Be proud of what you studied, Honorable Sirwani. If somebody says, Senyon, you're not a doctor, I'll not take offense. But as I finish up, Right Honorable Speaker, to the Attorney General. Attorney General, please do guide us. What gets to be the ultimate remedy? Because my worry is, whatever we pass here in Parliament will be taken as advisory, and government can choose to follow it or not to follow it. So if somebody was defrauded, as you're saying, Right Honourable Speaker, and then Parliament cannot help them because it will be advisory, how do we cover ourselves as a country so that tomorrow investors don't say, we shall not come, you're defrauding us?
Yes.
Also, how do we make sure an investor does not defraud us? So that's the legal direction that I'm hoping the Attorney General helps us with. Otherwise, we don't want afterwards, it was just advisory, we abandon it and move and do whatever we want.
It's interesting. Lope thinks because Silwani is a gynecologist, he shouldn't contribute to the debate. Right Honourable Speaker. Right Honourable Speaker. Right Honourable Speaker, of course that's a joke. That's a joke, and it's a light moment, and I want to appreciate Lope once again. You see, the ideal thing to do is to look at the prayers of the petitioner in the petition. What are they praying for? And based on the facts as they have been said before you, you are able to determine what prayers they qualify for and what they do not. Do you understand? For example, we all agree, or we at least have come to know, that the concession was null and void. So, but they had acted upon it, invested, paid money, Do we simply say you paid for something that does not exist? So, even your proposal can come in answer to their prayers. That's why I'm saying I do not want to be the one now to make the decision for Parliament.
Yes.
I want Parliament to make a decision,
Honorable
but
Akamba.
guided by the prayers.
Yes,
Thank you.
Honorable Akamba, Honorable Baka is back. Then
for government actions. You are aware, before those people came here, they went to court and exercised their right. And court told them that they could not seek remedy in court. The best thing they should have done is to go to arbitration. I'm not sure if they exercised that or not. That matter was, just let me finish. That matter was already determined by court. By asking Parliament to deliberate on this matter, don't you think Parliament will be moving in the direction? Let me raise my clarification.
I'm going to clarify on your issue.
You hear and you allowed me to No. Let me raise the clarification issue, then you've
already sought clarification, and I'm ready to
clarify what I've not raised. You only listen. In this matter, as rightly observed, their interests for this country and their interests for investors, for whatever reasons, those are all good interests. But what we want is a fair deal. Now, my clarification is, since those matters were already decided by the court, do you think by allowing Parliament to go and make recommendations
that one was already decided upon?
Tibet-Hima paid part of the concession fee in that concession agreement, which was a nullity. They also benefited from government through sale of electricity, which the UETCL, Uganda Electricity Transmission Company Limited, for power supply for Mubuku 1 hydro project. So even in that nullity, they still were collecting money from government. So I would like to ask the August House that I want to ask the August House that we pass the report with amendment, because I have no responsibility.
Yes.
That we go and reconcile against the money that they made, and then we come back and report to this House.
Or you pay them, or
whichever,
they pay
because
us.
they also took money from us in this illegality. They equally also made money.
What the amendment we are making is removing from political responsibility to collective responsibility. Are we together? Are we together? Honorable members, I put a motion for the resolution of Parliament to strengthen accountability mechanism and no, that's wrong. That the report on the Committee of Environment and Natural Resources on petition by Tibet-Hima Mining Company Limited against termination of their concession agreement with the government of Uganda be adopted by this Honorable House with amendment of political responsibility to collective responsibility be adopted by this House. Those in favor say on the contrary, nay. The ayes have it. House adjourned tomorrow at 2.